My name is Anthony Badaloo. I'm an accountant, and along with a couple of other people, few people, we've been investigating and analyzing the forensics of the alleged bankruptcy of Michelle Young, and we're assisted by Mr. Tariq Siddiqi, who's a legal strategist and does a lot of work on the social media, and Gedaljahu, the author of the famous book, The Forensics of Legal Fraud, co-authored by Bradley Meyer, which is being used by criminal defense lawyers up and down the country. So here we go. Murder mystery suspense, as many of you will know. Scot Young, his death has been claimed as a murder by Michelle, but we'll come to that. Michelle Young bankruptcy petition debunked. Authors Anthony Badaloo, Tariq Siddiqi, Gedaljahu. I must point out we've had assistance from many people far and wide. So we're going to go through a series of questions, about half a dozen, and the answers, and we believe that will prove conclusively what our point is. Michelle Young is not bankrupt. Question 1. Why is the petition procedurally defective and an extortion? Quote from the petition: "The debtor resides in England and Wales. I present this petition to the Central London County Court." End of quote. The statement above was made in section 2 of the petition. This is contrary to the facts, as the trial of the bankruptcy proceedings took place in the High Court, which does not have any jurisdiction to entertain individual bankruptcy petition cases, in accordance with the Insolvency Act 1986, Rule 6.9, brackets 2. Only the defendant's county court can issue individual bankruptcy proceedings as per Rule 6.9, brackets 2 of the Act, pursuant to the statutory instrument, where I quote, "Court to which petition to be presented, 6.9, brackets 2. In any other case, the petition shall be presented to the county court for the insolvency district in which the debtor resides." D. Rule 7.3, brackets 2 states, "No proceedings shall be filed in the central office of the High Court." E. The case number 1814/2015 is not a county court case number. Question 2. Has Michelle Young ever been served with any petition issued by the court as stated in paragraph 2 of the quasi/false petition? Answer A. Michelle Young has never been served with any petition issued by the court. The presentation of the bankruptcy petition was made by David Ingram and Richard Hicken, both of Grant Thornton LLP. The private individuals David Ingram and Richard Hicken have no standing whatsoever in the proceedings as they presented themselves on the petition. The individuals did not state under what authority they are acting and are not a legal entity in the proceedings. Affirmed by the judgment by Mr. Justice Morit in the case of Dubai Bank Limited versus Gajadari and others, we quote, "Proceedings are a nullity where the plaintiff does not exist as a legal entity." Question 3. Did the court receive as evidence attached an affidavit or statement of truth by the alleged petitioner as stated in paragraph 3 of the taxation order? Quote from the petition: "The debtor is justly and truly indebted to the petitioners in the aggregate sum of £84,430 by an order of the High Court of Justice Senior Court's Cost Office between Mr. David Ingram, Mr. Richard Hicken, and Ms. Michelle Danique Young. It was ordered that Ms. Young pay to the petitioners the sum of £82,000 and £2,430 for costs by 6th of March 2050. Answer: this is a false statement. David Ingram and Richard Hicken were never party to those proceedings. Michelle Young had never had any orders pronounced in court in favor of the two individuals presenting themselves as petitioners. As the petition is based on an alleged court order, it is not valid as it is not in the prescribed form 6.9 and not 6.7 as required under section 268(1)(a) or b of the Insolvency Act. Is there any documentary evidence to support point 3? That's a new question. The above mentioned debt is for a liquidated sum payable immediately and the debtor appears to be unable to pay it. That's what they said on the petition. Answer A. The imposter petitioners, David Ingram and Richard Hicken, did not supply any evidence in support of the statement. B. The statement that the respondent is unable to pay was made with the intent to obtain a bankruptcy order to deprive the victim, Michelle Young, of her freedom and liberty. C. Allowing them to take multi-million pounds under the false authority of the court. Question 5. Paragraph 4 in the petition stated that the debt is for a liquidated sum payable immediately and the debtor appears to be unable to pay. Is that a true statement? On the 10th of March 2015, a statutory demand was served in respect of the above debt. Court orders. Quote. Answer. Sorry about the interruption. On the facts and the law, it is an admission of an abuse of process as stated above, section 268(1)(a) or b of the Insolvency Act 1986, amounting to extortion. As the claim is based on a quasi-liquidated debt on a court order which does not exist. Paragraph 5 refers to a statutory demand being served on the debtor. Is this a valid evidence? Question 6. We quote from the petition, "We do not, nor does any person on behalf of us hold any security on the debtor estate or any part thereof for the payment of the above mentioned sum." This is a false statement knowingly made with intent, contrary to the true facts. Namely, they have been presented by Michelle Young an instrument, namely a court order, by Mr. Justice Moore, case number FD07D02865, in the sum of £26 million, on which Mr. Justice Moore pronounced in the judgment. Question 7. The court file, which Ms. Young received a copy of, all the data referring to each step in the proceeding, shows no evidence in the form of receipts that the court's fees have been paid to issue the proceedings, as required under 7.30 of the Insolvency Act, where we quote, 1. In respect of all insolvency proceedings, the court shall open and maintain a file for each case, and, subject to directions of the registrar, all documents relating to such proceedings shall be placed on the relevant file. 2. No proceedings shall be filed in the central office of the High Court. So in answer, there was no receipt for the payment of the deposit contrary to the insolvency rules, and we quote, Statutory Instrument Part 6, Rule 6.10, brackets 2, quote, no petition shall be filed unless there is produced with the receipt for the deposit payable on presentation. As it appears and is affirmed by the High Court, they do not have computer caseman records as required under Rule 7.27 of the Insolvency Act 1986. We quote, the court shall keep records of all insolvency proceedings and shall cause to be entered in the records the taking of any step in the proceedings and such decisions of the court in relation thereto as the court thinks fit. Summary. In conclusion, for the reasons in this dossier, Michelle Tariq Young is not a bankrupt. But like millions of others, the procedures and administration of the courts have been abused and manipulated with intent, as she believes to silence her and cover up the fact that Scot Young's death was a murder. The legal profession, the judiciary, and the police, for reasons unknown, have let her down. Legal strategist Anthony Badaloo, that's me, Tariq Siddiqi, Gedaljahu, Imgram. For a bit of fun, we're going to go through some of the documents, the actual real life documents, and as an end bit to the video. So here we go. Okay, so here we go. I think we're filming. Are we filming? Let's check. Yep. This is the petition itself, 1814 of 2015, form 6.7. So I've been told the bankruptcy proceedings is the only proceedings where there's two different forms, one 6.7 and 6.9. So if it's a liquidated sum payable, or is it statutory demand, and is it an abuse of process? So here we go. David Ingram, Richard Hicken, both of Grant Thornton LLP, but it doesn't say who they are, what capacity. It doesn't state anything here, and what authority they're acting. So there we go. This one, the court seal, it's from the High Court. It's stated here, I present this petition to the Central London County Court. So why has it got a High Court seal? And the High Court doesn't have any jurisdiction in any case, because it's an individual bankruptcy. and it doesn't have a Central London County Court stamp or any other county court seal on there. The debtor is justly and truly indebted to the petitioner in the aggregate sum of 84, according to an order of the High Court of Justice Senior Court Office, So all this is an incorrect statement. The above mentioned debt is for a liquidated sum payable immediately, and the debtor appears to be unable to pay. So there we go, come back to the statutory demand. If it's a liquidated sum payable immediately, then they can't be making a statutory demand. Where have we got here? So this is a confession of a crime. On the 10th of March 2015, a statutory demand was served upon the debtor. So you're serving false instruments and on an individual. We do not, nor does any person on our behalf hold any security, blah blah blah. There again, they hold order of £16 million, and maybe that's small change, but that's not a correct statement. And here again we got, on this page, we got the High Court stamp again, and that court seal is just according to the County Court Act 1984, section 135, that right there is a 7-year jail sentence. The backbone of our research, the forensics of legal fraud, it's available on Lulu. I think it's about £7, but it's a good authority on these matters, one of the best. And this is Lord Evershed regarding extortion. He said that this was extortion in bankruptcy law, the oppressive use of threat of proceedings in order to obtain some collateral advantage. The court considered obiter the issue of a strikeout of an action as an abuse of process. That was held. So a strikeout. So we are on the right path. And this is our authority. The proceedings are a nullity where the plaintiff does not exist as a legal entity. And that was established in Dubai Bank Limited versus Gajadari and others before Mr. Justice Morit, M-O-R-I-T-T. And documents are false if the circumstances are absent. So this petition, I don't know what paragraph on it actually got any standing in law. This is Michelle Young's registry trust. Anyone can do a registry trust printout for £10. And according to this one, all court judgments, bankruptcies, fines, it's registered here. So Michelle Young, England and Wales, judgments, nothing registered. High Court judgments, nothing registered. Fines and defaults, nothing registered. So where is the bankruptcy in the official system? And this is a freedom of information request made by myself, and we ask here how many cases have been struck out or declared void in all courts in England and Wales. What is the procedure for the court administration, not the judiciary, not the judge, not an appeal, to provide the victim with an affirmation that the case is void ab initio due to the non-payment of the court's fee? That's a huge one. They gave us some numbers here, and I believe since the civil procedure rules came in, I think it's 1999, April, something, there is about 140 cases struck out for this. So it's going on, and it's the way it's supposed to be done on these matters. Not for the judge, not for the judiciary, not for an appeal. The court will draft and serve an order on all parties to confirm a case has been struck out following non-payment of a court fee. I can't want it any clearer than that from the Ministry of Justice, in layman's language, all there. So this is the action taken so far. Michelle Young, we're now in March, end of March, coming up April 2018, and this was filed and stamped by the court. The courts don't want to stamp documents anymore, but they have to, because it's the only way you can prove you filed it. So 12th of September, and so it's a constructive notice delivered requesting an administrative order based on all the facts and evidence you've seen and witnessed. So to date, the court hasn't complied with the request, and this is where we need the enforcement authorities to step in. You're entitled to something which involves a lot of different other crimes and human rights abuses. We need some help from a uniform here. So this disputing the court's jurisdiction, fundamental defect, failure in service, Lord Green, the authority, and fundamental defect in the issuing of the proceedings, so that in effect the proceedings have never started, or where the proceedings appear to be duly issued but fail to comply with a statutory requirement. Option LJ in the Pritchard. It's as clear, it's very clear. And this is the Insolvency Act. If you've got a good neck, you can read that sideways, but it shows the statutory demand or a judgment or order, section 268 bracket 1b and section 268 bracket 1a. There are different proceedings, and for the statutory demand you need form 6.7, and if you have liquidated debt court order, it's 6.9. You can't mix up the two. It's a statutory requirement, as it's stated here. Fail to comply with a statutory requirement, or two, or half a dozen, or maybe a bit more than that. So here we go. Procedure for presenting and filing of petition. A petition may not be filed unless a receipt for the deposit payable to the official receiver is produced on presentation of the petition. 1. For service on the debtor. The following copies of petition must be filed with the court with the petition. And each copy must have the seal of the court applied to it and must be delivered to the petitioner. So we've already dealt with this one, the constructive notice. So it's basically now a criminal matter, and it's for the enforcement authorities to do their job. So there, in a nutshell, as you can imagine, a large number of UK bankruptcy, and certainly the ones that took place in the High Court, are void. illegal and void. So if you have any further queries regarding these matters, please feel free to contact www.scambuster.tv. Thank you very much. God's blessings.